Good evening. Today is Wednesday, 9 o'clock, and my name is Alena Shautsova. I am an immigration attorney from New York, and today we continue our legally speaking seminars. Today's one is dedicated to options, how one can sponsor himself or herself to become a lawful permanent resident in the United States. So let me start with saying that in most situations and for most ways one can become a permanent resident in the United States, a person has to have a family member or an employer who would petition for this person into the US. But there are very limited, or there is a very limited group of people who actually can sponsor themselves, who do not need an employer or family member to be sponsored into the United States. Most people who ask me about these options, I tell them, listen, you must fall into one of the two categories. You either have money or you are very smart. So let's start with the money. For one to sponsor himself or herself into the United States, there is a category called EB-5, which requires that the person invests into the United States, puts at risk at least $1 million in certain situations, and sometimes it's $500,000. $500,000 can be the amount can be lowered to $500,000 opposed to $1 million when a person is investing in a regional center, or the person is investing in a special area that is using a lay person term would say area is in need. Special areas designated that suffers from unemployment and other economic has other economical troubles. So $1 million. What does it mean? Well, it means that a person would have to basically be ready to never see the $1 million, even though it is an investment. The money that the person is investing would be considered at risk, meaning that the person cannot hold on to the money. It should not be the money that the person himself or herself will be using if granted permanent residency in the United States. $500,000 in regional center. What does that mean? It means that it's not you, it's the regional center who's going to be effectively managing your money, even though that one of the requirements for the EB-5 category is that the person will be involved in a managerial capacity of some sort connected to the investment. So I must say that that first option is available to a limited amount of people, of course, because not everybody can just put at risk $1 million or even 500,000. Another thing with this option is that sometimes people approach me and say, well, okay, I have $1 million, I will invest. Does it mean that my whole family can move to the United States and will be granted green card? Well, here how it works. First of all, nobody can guarantee you that even with $1 million, your application for green card will be approved. It means that, like any other application for immigration benefits, it will have to be approved by USCIS. The company or the investment, it's something more than just a company. Its whole investment strategy has to be approved by the USCIS. So there is a chance that there is always a chance that application might be denied. Besides, if the certain family members or children, let's say children are over 21, they cannot immigrate with you. They're considered a separate family, and they will have to find other ways to come to the United States. It's also true for your uncle, aunts, or parents. They're not considered your immediate family with this regard. It's only your wife and your minor children. So that's important to know. So let's say you don't have $500,000 to $1 million to invest. What are your options? Well, then usually you have to be really smart. There is a special category, it's called EB-1, that is designated for those who may be sponsored what's called labor certification. When we're talking about traditional sponsorship by an employer in the United States, usually in most case scenarios, employer has to test a U.S. market before employer can hire a foreign worker or sponsor a foreign worker for a green card. And this test has to show that there are no U.S. In the United States, amongst the people who already have employment authorization or U.S. citizens, there is nobody who fits for the position that this employer is offering to you. Department of Labor actually oversees this process, and it's a very, I would say, artificial process in terms of testing, which one has to go through to show that there are no available U.S. workers, that the foreign worker will not take someone else's position. So it's not an easy process, and it's not impossible, but very often it's very hard to go through this process. And the United States government, realizing that, created EB1 category for those people who are so important that they do not need to go through this process. Who are those people? Well, those are people of extraordinary abilities, people who fall into category of multinational executives and managers, and people who can fall into category of outstanding professors and researchers. Now, I cannot go through every little detail because each of these three categories has its own criteria that one can meet. But I can tell you this, that the title of these categories are not that simple, or better to say that I very often receive phone calls and person says, for example, well, I know that I fall under extraordinary ability category because I meet the test. I have 7 points out of 10. People read online, basically, that to meet criteria for self-sponsoring in a first preference category and extraordinary ability, they have to have articles, they have to be recognized in the communities, they have to be an acclaimed artist or a scientist or musician, and they believe that they already qualify and they can sponsor themselves. Well, this is not just as easy as it seems. Each category does have its own criteria, but it's much deeper than just words that are on the surface. Basically, when the USCIS says, well, you have to be a person of extraordinary ability, there is a body of case law and regulations behind that. It means that the person has to have an international, or usually an international, has to win an international prize of international be significantly acclaimed internationally. And the level of this prize has to be very high, maybe an Olympic medal, or it has to be a Nobel Prize. So this extraordinary ability category, the person has to be a truly outstanding artist, scientist, sometimes even a businessman. It depends. But the level of acclaimed and achievement must be very high. Then we have outstanding professors and researchers. That's basically this category also can be used by a relatively small number of people. And then we have multinational executive and managers. This category is actually pretty popular because all big companies that have a branch overseas and branch in the United States, they utilize this specific category for its managers and executives to avoid the process of labor certification, or PERM and PERM. This is the process I mentioned earlier, the process where you have to test the US market in order to be sponsored. And I will go back to this category. Let me mention one more option when a person can sponsor him or herself. This is the category of EB2, and people fall under this category if they are members of the professions holding advanced degrees or persons of exceptional ability and they may qualify or they qualify for national interest waiver. This category is usually used by physicians, doctors of different kinds, those who can show that after they received education and they performed maybe clinical studies, or they published a very important article that had huge influence on the profession, they will be useful in the United States. It's called National Interest Waiver. What it means is that that person who is an applicant under this category, his level of acclaim and abilities is not high enough for the first category, extraordinary ability, but this person is asking the United States government to waive for him or for her the necessity of testing the US market, because the person is saying that, well, you know, I can contribute into your country and it will be very useful, and you will see will be a very great benefit to the United States for me staying here and be able to work. That's what national interest waiver is. And of course, as with every of these categories, there is a formal criteria that one's application has to correspond to, but I will not mention it here because it's very detailed, and even I handled some of this I cannot say tons of those waivers, but some of those waivers I still have to each time do my research because the law is changing, and it's a very there are formalities that the person has to follow in order for his or her application to be granted. So let's say you don't have $1 million or 500,000. You're not super smart, but you are a business person, and what options are there for you? You still would like to live and stay and work in the United States. You believe that you are quite a good businessman. Do you have any options? Well, you do, but they will take a little bit longer, and you will have to first probably get one of the non-immigrant visas rather than being sponsored directly for an immigrant visa. Some people who come to me and ask me about these options, I recommend that they use L1 way to immigrate to the United States. And that's how it works. L1 is a visa. It can be L1A, L1B. Also depends on the person's role and abilities and experience. But basically, it's when a person or a company that been successful overseas, opening a branch in the United States, or a sister company, or they have the same owner, and later the company that's overseas is transferring its manager under L1 visa or its president to the United States. And such a person usually gets an L1 visa. What happens next is that the United States branch already is sponsoring that L1 visa holder for a green card in EB1 category which does not require a labor certification. So this way is very popular among people who do not have 500,000, but they have a stable business and they would like to actively participate in the development of its branch of their business's branch in the United States. They can oversee, manage the branch, and they have to have, or the company overseas does have to make investments to develop the business in the United States, but the criteria for that business is not as strict as for the EB5 business. So this is a good option for those who have some money, let's say 100,000 to start, 200,000 to start, and they would like to build business in the United States, and they're not mega smart as I'm not mega smart. I mean, they're not, you know, some very famous researchers or professors or people who won a Nobel Prize. So this is actually a very realistic way to sponsor one into the United States. We say it by yourself, but it's really through your companies. And of course, USCIS is going to oversee the process. First, they give one L1 visa for a year, and it's called a new company, and then a person has to file for an extension. And if the new business is actually not just a shell, but it's a real business, it's operating, it's developing, the USCIS will grant that person's L1 visa for 3 years. And after this extension, the company in the United States can sponsor the person for their green card. So there are other not so popular ways for one to stay in the United States, but usually it's when one is already in the United States, not when one is overseas, how one can stay in the United States without anybody's help. But usually something bad has to happen to the person for this to happen, unfortunately. So I hope this was helpful, and if you do have further questions, you're welcome to visit my website, www.shautsova.com, or call my office at 917-885-2261. Thank you.